As he mentioned, I am going to talk to you about arbitration and the particular issue of consolidation, the situation you have where one party has a dispute with multiple parties similar to the same dispute and wants to put them all in one proceeding. Now, this comes up very commonly in litigation, as you know, but in arbitration it can come up as well. But arbitration presents some very unique problems, and those are the unique problems are what I'm going to talk about today. Now, there is an article in your materials that discusses this that I wrote, and you'll see that it addresses it in the context of reinsurance arbitrations. The reason for that is that I wrote the article for a reinsurance publication. But the same issues can come up in any other context. You can have a situation, say, with syndicated loans where you have a dispute between one borrower and multiple lenders, between landlords and multiple tenants, franchisors and multiple franchisees, and of course, one seller and multiple customers and whatever claim they may have. And it is becoming a growing problem today, in part because arbitration itself is growing. And one of the reasons growing of particular interest for those of you on the defense side is as a defense against class actions. In theory, you can have a class action in arbitration. The American Arbitration Association has a whole set of rules for those, but as a result of a series of recent Supreme Court cases, it is all but impossible to get a class certified in arbitration if you oppose it, and almost every defendant will. And so going back to Bill's topic of antitrust investigations, if your company or your client is the subject of a price-fixing investigation by the U.S. Department of Justice, as sure as night follows day, there will be a class action following that proceeding, even if you satisfy the Department of Justice that your client is innocent. And that case will be brought as a class action, and if a class is certified, it'll be certified probably on behalf of every purchaser of the company's products in the United States for the past who knows how many years. And so before you know it, you are facing a bet the company case. However, in arbitration, if you can get that claim in arbitration, and courts will require arbitration when they're covered by arbitration clauses, even for an antitrust case, you've avoided the class action. And so what the plaintiff's lawyers will then fall back on is an effort to kind of get as much as they can of a class action by consolidating as many of those cases as they possibly can into one massive arbitration. But to avoid that then, we have to look at the issues. Now, why is it a special problem to have consolidation in arbitration? The reason is that arbitration is the product of agreement. You don't have to agree to be in the Southern District of New York, but you do have to agree to arbitrate and be before a panel of arbitrators. So Mr. Brown and Mr. Turquoise have a contract, and the contract has an arbitration clause that says that any dispute relating to that contract will be settled by arbitration. Well, Mr. Brown may have that same contract with thousands of other customers, for example, with a similar arbitration clause. The same issue may come up with all of them, and they would want to put them all into one case. Now, they have a situation where each of those opponents has agreed to arbitrate with Mr. Brown, but they've not agreed to arbitrate with each other. And so therein lies the problem. How do you consolidate those cases? Well, the easiest way is to, like everything else in arbitration, let's just agree. It'd be all simple to have one big case. Let's all agree to that. Well, you're not going to agree to something unless it's in your interest or your client's interest. So it's important to step back and consider what are the benefits of consolidation and how do they affect each side. And as what you'll see is rarely is there an agreement on consolidation. The benefits fall into two categories. The first one is to avoid duplicative proceeding. Mr. Brown has the same claim against how many other customers or suppliers, and just wants to, just for the sake of efficiency, wants to have one set of discovery, one round of briefing, one hearing. Doesn't want to have to do the same case over and over and over again. It's a lot more efficient to do it that way. And also, by consolidating the claims, he has a lot more leverage against the defendants because they're more economically feasible. But on the other side, don't have the same interest. For each of the opponents of Mr. Brown, they have only one case, whether it's consolidated or not. And the only effect of consolidation is that that one case now becomes much bigger and much more complicated. And in addition, they now face a plaintiff who can bring the claim against them much more efficiently. So they're not going to agree to that. The other interest in consolidation is to avoid inconsistent results. And you're probably all familiar with how this works, but one good example to understand it is a case that was in litigation, but certainly illustrates it, and that is the property insurance claims for the World Trade Center after the 9/11 losses. Larry Silverstein had those insured, as most large property is, through excess of loss contracts. So there would be one coverage for, say, the first $10 million of a loss, another for above 10 up to 20, and on up the ladder. And that situation raised the issue of how many losses were there. Were there two losses because there were two airplanes that hit? Or was there one loss because it was one property that was destroyed as a result of one terrorist plot? And as you can imagine, Mr. Silverstein wanted to consolidate it because what he didn't want to have a situation where the resolution for the insurers lower on the ladder said, well, there's only one event, we only pay once, and you collect the rest from the people up above, and then the resolution for the insurers up above is, oh, there are two events, we pay nothing, collect twice from the people down below. He wouldn't get his claim paid. But of course, the insurers have the opposite view. None of them face a risk of an inconsistent outcome. They're all going to face one result, whatever it is, and they're much better off putting their opponent into this bind where they have at least the risk of an inconsistent result. And this can come up in other situations as well. Another common situation is insurance coverage for pollution claims, which spread over multiple periods. So typically when you have an arbitration that's consolidated, the question is, can a court compel the parties to consolidate over their objection? Is there any way to make them do this? Now, this is an area where arbitration is much different from litigation. In litigation, there's a rule, Rule 42A. The court can consolidate over your objection, and they frequently do, and they don't really give a lot of weight to the defendant's objection of, oh, I'd really just rather have my own case. But what about arbitration? The principal arbitration statute in the United States is the Federal Arbitration Act. And what it says about consolidation, nothing. There is not a word in the statute about consolidating arbitration. And what the federal courts have done, how they have interpreted this, it says, in the absence of any authority in the statute authorizing courts to compel arbitration, there is no authority to do this. If you want to have your case consolidated, you have to ask the arbitrators. This is an issue for arbitration. Now, I have to say there's one exception to this. Most states also have their own state arbitration statutes. Some of those statutes authorize the courts to order consolidation, so you may be in that situation, but even then, it's not all that clear, because here then you have a split between the federal law and the state law. And the Federal Arbitration Act applies to any arbitration involving interstate commerce, even if the enforcement action is brought in a state court. And although the issue is still open, there is a strong argument that the federal position on consolidation would preempt any contrary state law. If the rule under federal law is that this is for the arbitrators to decide, a state law can't then take that and put it back to the courts. So what that means is that in most cases, and possibly all, in order to answer the consolidation question, we have to have arbitrators. So you have to select the arbitration panel. So let's look at that process. How do you select arbitrators? Now, an arbitration panel is either going to be one arbitrator or three arbitrators. That's going to be set out in the arbitration clause. And the arbitration clause usually will also set out how you go about and pick the members of that arbitration panel. And under the Federal Arbitration Act, if those steps are laid out in the contract, they must be followed. If they are not followed over the objection of one party, the award can be, any award that the arbitrators give can be vacated. And there are very few grounds for vacating an arbitration award, but that is one of them. So let's look at some typical clauses. This is a very common clause for appointing a three-member panel. Each party picks one arbitrator, the party-appointed arbitrators, and then those two pick the third arbitrator, who is going to be the chair of the panel, or often called the umpire. And a key feature of this is that there are two party-appointed arbitrators. Each party gets a unilateral choice of one member of that panel. And this is an essential feature of tripartite arbitration, because that party-appointed arbitrator, well, has to be disinterested. You can't pick your brother-in-law, but doesn't have to be completely neutral. You are entitled to pick an arbitrator that you think will be favorably disposed to your case. And since you are entitled to do that, if you fail to do that, you have committed malpractice. You just have to do that. You can pick someone that you think will be very effective in moving the umpire in your direction in deliberations. That's often a critical factor in how you pick that person. And then, depending upon the rules that govern your particular arbitration, you may be allowed to have ex parte communications with that arbitrator up to, that's usually some cutoff date prior to the hearing. So you see, this is just critical, but it is something that might not work very well, with multiple parties on one side. I mean, they all have to agree on who the party arbitrator is. And even if all their interests are aligned, you all know lawyers, that's going to be very difficult. But it becomes a particular problem when you have the risk of inconsistent results. I mean, how is it that the people higher in the ladder of Silverstein's insurance coverage are going to agree with the people lower? I mean, they actually have opposite views in this case. So you have a situation where one party is inevitably denied the benefit to make a unilateral choice of the party arbitrator of its preference, and that could raise a question about the fundamental fairness of the proceeding. Now, there's also a matter of appointing a single arbitrator, either the one member of a single arbitrator panel or the umpire in the case of a three-member panel, in case the two party arbitrators are unable to agree on who the umpire will be, and as you can imagine, that happens an awful lot. This is a very common term. Each side nominates three candidates. You then strike two from the other side's list, and then there is a choice by lot of the two remaining candidates. The common practice is, not always, but common, is that you decide based upon the closing of the Dow Jones Industrial Average the next day. If it's an even number, one side wins. If the odd number, the next side wins. There are a lot of problems with this process, but it seems to continue to be used nonetheless. But just as with the party-appointed arbitrators, it doesn't work very well when one side has multiple parties who don't agree, because in a sense, they're not going to get their list of candidates that they all are comfortable are the umpire that they want, whereas the other side certainly will. And they similarly will have difficulty agreeing on who to strike. So you have a situation where, once again, the process doesn't work very well for the party on the side with the multiple parties. Now, another way to do this, there is a process in the commercial arbitration rules of the American Arbitration Association for choosing an umpire. The AAA staff will hear about your case and look at their national roster and pick a bunch of names of people that they think would be appropriate. Usually it's a list of 10. And then each side can strike candidates that they don't want, and then they list in order of preference the ones who are left, and then the AAA then picks the one with the highest combined score. This is a more complicated process, but it doesn't avoid any of those problems before. One side has to have some consensus, whereas the other side gets a unilateral choice. Sometimes these problems are avoided if the arbitration clause includes what's known as an act as one clause. It just says if there are multiple parties on one side, you're all going to act as though you're a single party. Now, the example I hear says reinsurer, because that's where I pulled this out of, but you can see this elsewhere. This doesn't solve any of these problems. It just says you agreed to this, so you deal with it. So it isn't particularly helpful. And if you are a company with arbitration clauses and you have one of these clauses in your contract, you might want to step back and think, do I really want that? Am I going to put myself in a bind that I don't want to be in? But primarily, you don't see these very often. It's not a very common term, so this isn't usually the solution that you're going to want. Under the Federal Arbitration Act, if the process fails, as it almost inevitably will with consolidated arbitration, then the court can appoint an arbitrator. The problem here, once again, is that that just sort of flips the problem to the court. I mean, what is the court going to do? Is it going to let one party have its own choice of a party-appointed arbitrator, but then appoint the party-appointed arbitrator for the other side? You, in effect, have one not neutral arbitrator and then two neutral arbitrators. That really isn't the process the parties agreed to. Similarly, with the umpire selection, are you going to hear one voice from one side and then a cacophony of different views from the other? It is hard to see how this process will work out to the advantage of the party with the multiple defendants. But then that brings us back to the question that we had before. Who decides? You remember, the Federal Arbitration Act's position is that consolidation is for the arbitrators to decide. Well, which arbitrators? I don't think any court or very many courts have really addressed that seriously. We've already seen the problems you have appointing a panel in a consolidated arbitration, but now you have to go through that process even before you decide whether the case is going to be consolidated. Now, some courts have said, well, the first panel to be put together will make the decision of consolidation. Well, that's great for the parties to that contract, but what about the other defendants who are not part of that panel? How is it that you can compel them to a consolidation decision by a group of arbitrators that they had no role in appointing? I don't believe the courts have ever addressed that issue, but I'm quite confident that it could never really be enforced, given the fundamental point of the arbitrator's authority is the agreement of the parties. The alternative is then to have every party put together its own panels, and they can all decide independently whether or not they want to consolidate with each other. That's not likely to get very far, because it means most of the arbitrators are going to put themselves out of work. But there's also a problem because, in effect, what it says is that we, the arbitrators, will defer to this different group of arbitrators to decide this case. And the one principle of arbitration is that the arbitrators cannot delegate their decision-making authority to somebody else. That becomes a problem as well. So the bottom line is that there really aren't any solutions to this problem right now, and I apologize if the title of my speech raised any expectations, but I have to caution you that this is a problem when you find yourself in it. But also, if you are the party who is opposing consolidation, you have very strong grounds to make your objection, much stronger grounds than you would have if you were opposing consolidation in a lawsuit. Thank you.